good morning, good afternoon, or good evening, depending on wherever in the world you are. On behalf of the Department of Law, North South University, it is my privilege and utmost pleasure to invite you to today's session on the World Trade Organization in a time of fragmentation. Is there a path forward? It is my utmost pleasure to warmly welcome Professor Meredith Kolsky Lewis to speak on this topic. But before I invite Professor Lewis to speak, let me say a few words about our today's topic. The World Trade Organization, in many ways, in my view, is at a crossroad, and it is facing some serious questions about its existence, about its Doha Round agenda. Some scholars would perhaps say that Doha Round agenda is almost clinically dead. Some would say that WTO is moribund. Some would say that this is no longer a multilateral body as such, it is more a plurilateral body. And of course, there has always been some sort of FTAs parallel to the WTO, but the recent wave of FTAs and mega regional FTAs are perhaps significantly different from what they used to be around 2 or 3 decades ago. And the topic that Professor Lewis has chosen for this evening, in my view, raises many questions, some of which may have multiple answers, and some of may not have any answer depending on your perspectives. These are so value-laden, and they involve not just legal or economic issues. Often they are intrinsically interlinked with some political and other issues. So I'm really interested to see what Professor Lewis has to say. And of course, dear audience, your questions, your participation. So without any further wasting of time, let me allow Professor Lewis to start her topic. Professor Lewis, the floor is yours.
Thank you so much, Professor Islam. It's a pleasure to be with all of you this evening. Thank you for taking time at the end of a long day to engage with this discussion. I will do my best to leave plenty of time so that we can have a chat, because that is the most interesting part, I think, for any presentation, is to have a chance to discuss the issues together. It's my real honor and pleasure to be with you. I met Professor Islam maybe 16 years ago, I think, in New Zealand, where I was a new academic and he was completing his PhD in Australia. So it has been a long time since we have seen each other, although we have been in touch over the years. So it's my great pleasure to be with you today. So Professor Islam introduced the topic very well, so I will just kind of jump in. I'm going to give a bit of an overview of what has happened over time, the last 20 years or so, with respect to free trade agreements and the WTO and negotiations to advance the agenda of trade liberalization, whatever that may mean. And then kind of present the crossroads that Professor Islam suggested, as well as some thoughts about how we should maybe think about moving forward or possibilities. And then we'll open it up for discussion. So first of all, the WTO is, the World Trade Organization is somewhat synonymous with what we often hear as the multilateral trading system. When we refer to the multilateral trading system, we mean the WTO. The WTO is, of course, an expansion of the trade liberalization process that began with the GATT, the General Agreement on Tariffs and Trade. And the GATT is itself part of the WTO. So during the GATT years, as many of you will know, trade negotiations were largely conducted in rounds of talks that went on for years and years, where the GATT signatories were mostly concerned with lowering tariffs. And when the WTO was formed in 1995 or came into effect in 1995, the expectation was that trade liberalization would continue to occur in a similar way. So although it's now the WTO, that there would still be rounds of discussions to continue to liberalize trade. And certainly at that time, 1995, it was very much the view of the members that this multilateral forum was the preferred way to liberalize trade or to agree on other forms of trade-related measures. So that this would be kind of the first best way of opening up economic ties, with free trade agreements being a second best. After a few years of the WTO, the members decided to launch a new round of negotiations, such as what had happened under the GATT years. However, the theme for this round wasn't so much tied to tariff reduction, although that was, of course, a goal, but the round was named the Doha Development Round, with the thinking that there would be a particular emphasis on the priorities of developing countries. Notwithstanding that objective, the negotiations largely collapsed after several years. And although that collapse, in my mind, happened in 2008, the round still, if you look on the WTO website, it still shows up that we are in the Doha Development Round, but no one really thinks that has been happening for many years. So effectively, the round is over, but because it hasn't been formally abandoned, nothing has really taken its place. So effectively, the WTO has not concluded any major comprehensive set of negotiations since its founding. So over time, this has led to some frustration on the part of various members. Some developing country members, perhaps most developing country members, are quite disappointed and frustrated that the development promises have not been realized. Some other members, perhaps most of the developed country members, are quite frustrated that there has been no progress on further opening up of economies within the WTO. So although the idea of multilateral liberalization, I think, probably still remains the ideal way of liberalizing in the minds of trade negotiators and diplomats and officials, countries across the board have grown a bit frustrated. So starting around mid-2000s, when the Doha negotiations were floundering, WTO members started pursuing more free trade agreement negotiations. Now, there had, of course, been some free trade agreements already in existence. There are some quite old free trade agreements. But for the first several years of the WTO, members were kind of all in on the multilateral process, and we're not turning to FTAs. But starting sort of 2006, 2007, 2008, countries started turning to negotiating free trade agreements. Now, the idea of free trade agreements, for those who are not very familiar with the WTO, is a little bit at odds with the principles of the WTO. So one of the core principles of the WTO is this idea of most favored nation, that all the members of the WTO are in a club, and all the club members are entitled to the best treatment of every other club member gets. So if I am entitled to a 5% tariff from member A, all the other members in the club are entitled to that 5% tariff. If the member giving the 5% tariff lowers that tariff to 3% for me, they have to lower it to 3% for everyone else. So the idea is we're not playing favorites within the club. Everyone in the club gets the best treatment of everyone else. And this leads, in theory, to countries outside the club to want to come in to get that best treatment. But free trade agreements are very much in tension with that most favored nation concept. Free trade agreements are an exception to that rule and will allow two members of the club or more to form a free trade agreement and lower tariffs to zero just between themselves. So I can give that zero rate to Professor Islam if we form an FTA with each other, and he can give that to me, but we don't have to give that zero rate to everyone else. So suddenly, some are more equal than others within the club. Some best treatment is better than the best treatment others are entitled to. So when the rules were drafted, the provision that allows for FTAs was seen as an exception that would not come up very often. And in fact, at first, it was not invoked very often. However, now, sparked by this change in the mid-2000s, the exception is perhaps the norm. And every WTO member has multiple free trade agreements, and there are hundreds and hundreds of them currently in existence. In addition to free trade agreements as an exception to MFN, there are other types of exceptions to MFN as well, including the generalized systems of preferences offered, the European Union's Everything But Arms program for LDCs, least developed countries as an example, the ability for developing countries to form preferential trade agreements with each other that are less comprehensive than free trade agreements, but nonetheless provide preferential market access to each other. And so some have said that most favored nation has really become least favored nation, because almost everyone is entitled to better than most favored nation from many other countries. In fact, I believe the European Union gives better than most favored nation treatment to all WTO members except about 5, one of which is the US. So the European Union either has a free trade agreement or gives GSP or otherwise provides better than MFN treatment under one exception or another to almost all WTO members. So what about these FTAs? Well, until maybe the last 10 years or so, trade agreements did fall into kind of two categories, the WTO and then FTAs, which were primarily bilateral, just two countries, generally a large economy and a smaller economy, or two smaller economies. But there weren't any FTAs that featured two very large economies. If there were more than two parties to an FTA, they tended to be neighbors, so adjacent countries. As I said, there were no FTAs linking two very large countries. And the coverage was usually very similar to the WTO and mostly focusing on reducing tariffs, but often with some sensitive areas of the economies carved out. So a lot of FTAs that don't cover agriculture either at all or comprehensively, or might exclude textiles or other segments of the economy that the participants considered sensitive. But for the past maybe decade or so, there have been new trends. Although the regular type of FTA, traditional FTA I just described, continues to grow, we also now see quite a few FTAs with many countries, including some countries that are not geographically contiguous. We now have quite a few FTAs that feature more than one mega economy. We have coverage in these FTAs that goes beyond the WTO agreements, that include new chapters on areas such as e-commerce or state-owned enterprises that are outside the scope of the WTO agreements. And we also see negotiations that aren't in the format of a free trade agreement, but are negotiations amongst many countries on one specific subject. So for example, negotiations just on liberalizing trade and services. So with these new style FTAs, which cover more countries, more money, and new issues, here are just a few examples on the slide. So RCEP, of course, has, I think, 15 members. CPTPP has 11 and is likely to expand soon. We have the Japan and EU in an agreement together. Via RCEP, we have Japan and China and Korea in an agreement together. So we have mega economies in the same agreements. In terms of subject-specific negotiations, these talks have occurred both within and outside the WTO. Within the WTO, members have participated quite a bit in the services context in negotiating new agreements that not all members have participated in. So this is a departure from the sort of traditional style of rounds where all members are participating and all members sign off on the final agreement. These agreements have taken the format of what's called a critical mass agreement, which is where sort of a very high percentage of the trade in a given sector, for example, information technology, participates in the negotiations, and then the end result is provided to all members, including those who didn't participate. The benefits are provided to all members. So the benefits are provided on a most favored nation basis, but the responsibilities only apply to those who participated. So everyone gets the benefits, but those who don't participate have no responsibilities. That structure of agreement is not easy to achieve unless you have all the major players in the sector willing to sign on. So countries are hesitant to form a critical mass agreement if you don't have critical mass, because they're worried about what we might call free riding. If, let's say, India is not on board, but India is a major beneficiary of obligations under such agreements, other members may not be willing to provide the benefits to India if India is not taking on responsibilities, for example. More recently, within the WTO, several different projects are underway, which have between, say, 50 and over 100 WTO members participating in these projects, which are called joint statement initiatives. They aren't yet called agreements because, among other things, there are disagreements within the membership as to whether these initiatives can actually be adopted or should actually be allowed to be adopted without the consensus of the whole membership. And at the moment, there are disagreements amongst the members, particularly, notably, India and South Africa have voiced concerns about the consistency of these initiatives with the WTO rules. Sorry, my slide doesn't want to advance. I'm not sure why. There we go. So how did we get here? If multilateralism is the first best, why the fragmentation? And perhaps the answer is that given the concept of comparative advantage, once some countries start down the path of forming these preferential agreements, it's very difficult to stay pure and stick only with multilateralism, because the competitors of your industries are gaining advantages from each other. So if you sit out and don't participate in that process, your industries become less and less competitive. So I have just a very simple example of this. So let's assume that in the absence of an FTA, we have a world that just includes the US, Bangladesh, and Australia. And the US has some product that its industry can sell for $10 a unit within the US. And the US imposes a 20% tariff on imports of that product from the rest of the world, which is just Bangladesh and Australia. Bangladesh is an efficient producer of this product and can produce it and sell it for $7.50 a unit. Now, Australia is also more efficient than the US and can produce and sell it for $8.50. So once the tariff is applied, the 20% tariff on the value of the product, that means that the Bangladesh producers, when selling into the US, a tariff of 20% of the $7.50, which is $1.50, will be added to the $7.50. So the Bangladesh producers would sell in the US for $9, but they're still going to be able to undercut, sell more cheaply than the US producers. So they're going to stay in the US market. The Australian producers, although more efficient than the US producers, cannot sell profitably in the US because of the tariff, because 20% of their $8.50 adds $1.70. So now their product would be $10.20 higher than the US price. So in this pre-free trade agreement world, Bangladesh is selling in the US and making money. Australia is not selling in the US. But now, trying to get my slide to cooperate. Sorry, it's a bit stuck. There we go. Let's assume that the US and Australia form a free trade agreement and they reduce tariffs to zero between themselves. That doesn't change Bangladesh's $9, but now Australia doesn't have the 20% tariff added to its $8.50. So now Australia can sell in the US for $8.50, but Bangladesh is at $9. Even though in the absence of any tariffs, Bangladesh would be the lowest cost producer. With the preferential treatment of Australia, suddenly Australia is cheaper than Bangladesh, even though Bangladesh would have comparative advantage without these tariffs and the free trade agreement. So as a result of the free trade agreement, Australia's item is cheaper than Bangladesh's. And the effect of the free trade agreement is to increase trade between the US and Australia and to displace trade between the US and Bangladesh. So what's going to happen in this scenario? If maybe Bangladesh would prefer not to have any free trade agreements, but you see this happen, and the Bangladesh industry is going to say to the government, hey, we just lost the whole US market to Australia. We need you to negotiate an FTA with the US. And so this dynamic has played out again and again and again and again across industries and countries throughout the WTO. As industries lose comparative advantage as a result of an FTA between their trading partner and their competitor, those industries lobby their government and say, hey, we need an FTA with that trading partner as well. And so they keep proliferating. And it's very difficult at this point, impossible, to break that cycle. So this leads to quite difficult choices for all members, but perhaps particularly for developing countries. The WTO framework provides a useful opportunity for developing countries to work together and to use their numbers as a counterweight against the inherent power that the large economies have. Within the WTO, because of the consensus practice, even a small country can object to an agenda or to an agreement, and it won't happen. So that's a lot of power. However, these increasing agreements that don't include all members are perhaps not attractive to developing countries in terms of their interests or their capabilities. Not all countries want to further liberalize intellectual property or open up more markets when industries are just getting started. So there's a desire to return to the multilateral framework. But how do we do this? How do we get developed countries back to the WTO negotiating table? This is quite challenging at this point, particularly because of all these FTAs. As I said, many of the FTAs have excluded sort of the most sensitive areas to liberalize, such as agriculture and textiles. But the easy things have been agreed to in lots of FTAs. So instead of having this big buffet table where everyone has things they want and they understand they have to give things in exchange, we now have a table that is filled with the things no one wants to eat. And how do we get people to go back there to get those overcooked vegetables when they already had their dessert, right? So I think I came up with this analogy when my children were small and we tried to hold out the reward of dessert to get them to eat their food, right? So in early days of these trade rounds, yes, it's hard to liberalize, but you would know that in exchange, you're getting a benefit from another country. Well, now all those easy benefits have already been attained through FTAs. So to come back to the table knowing that all we have left are these really difficult issues is quite challenging, particularly since in the past, the very large economies did not have FTAs with each other. So even if the US, for example, didn't really want to give concessions to developing countries, at least in these rounds, it was interested in getting new market access from Japan or the EU or other big players. Now that the big players are liberalizing between themselves, that draw is no longer as strong to get developed countries back to the WTO negotiating table. And unfortunately, it's not a situation where the developing countries can just say, well, we just won't play and everyone will have to use the WTO because that's the only choice. As the last 20 years have shown, the WTO is not the only choice. And developed countries are going to keep negotiating with each other, whether inside the WTO if that's permitted, or outside the WTO if that's not permitted. So just saying we have to go back to the way it was is not going to work. So what does this mean? Well, there are a number of implications of this dynamic. One is that fragmentation leads to the potential for more inconsistencies, including in dispute settlement. If we have multiple dispute settlement mechanisms addressing what does most favored nation mean, for example, we have the potential for inconsistent outcomes. For developing countries that aren't participating in these CPTPP type of new wave agreements with WTO plus chapters, it makes sense not to participate on one hand. On the other hand, those agreements are likely to be in a way multilateralized with the chapters coming up in new agreements, replicated in new agreements. And so to not participate in those rules that will spread is perhaps a problem. If those rules are multilateralized, that creates some legitimacy issues. There are countries that will have to accept those rules, but they didn't participate in their drafting. At the same time, developing countries' bargaining position is perhaps getting weaker because the bigger economies are liberalizing with each other and achieving significant gains for their economies. What's in it for those wealthier countries to negotiate with the developing countries? For the WTO, this of course puts us at the crossroads that was mentioned at the beginning. How does the WTO find its reason for existence again? What does it do to get back into the business of getting countries all together to agree on things? Should the WTO accept and embrace these plurilateral agreements? Should it give up on the idea of everyone agreeing to everything? I just want to conclude with some thoughts, and then we'll open up for discussion. It seems to me that there is still a value, notwithstanding these problems, in the WTO for developed and developing countries alike to keep the institution going. Even though MFN is now perhaps LFN, the value of most favored nation is strong. Just ask Russia, from whom MFN is now being withdrawn by the US and the EU as a result of the actions in Ukraine. The dispute settlement system, although currently under great stress due to the lack of a working appellate body right now, the dispute settlement system has been used significantly by developed and developing countries alike. And the WTO provides a very useful forum through its various committees for members to address concerns with one another that get resolved without the need to resort to dispute settlement, among many other benefits of the organization. I want to touch upon the idea of multilateral. So I mentioned at the beginning that the WTO is sort of synonymous with the idea of a multilateral trading system. But it has been the case for quite some time that because of the single undertaking concept, that in the context of the WTO, multilateral means everyone has to agree. So multi means all, but that's not what multi means. Multi means many, right? All is omni. I don't know a lot of Latin, but I do know that all is omni and multi is many. So this idea that multilateral requires every country to agree to everything is not helpful. It's not sustainable because we've seen that even one country can block something from going forward, and that's not useful. But it's actually not what has happened historically either. Historically, WTO members and previously GATT members had different responsibilities and rights. As we know, there is special and differential treatment, for example, throughout the WTO agreements. Least developed countries and developing countries do not have the same responsibilities as developed countries. And so I want to ask you, I want to leave you with this thought bubble that given that the TRIPS agreement, the intellectual property agreement, has a waiver for least developed countries, which has now been ongoing for 25 years and has been extended again, isn't that really like a plurilateral agreement? I mean, sure, LDCs are party to TRIPS, all WTO members are party to TRIPS, but if part of the membership doesn't have to comply with TRIPS, is that so different than negotiating a plurilateral agreement and providing the benefits on an MFN basis? So I guess what I want to suggest, perhaps be a little bit provocative, is that we always had plurilateralism within the WTO. And we shouldn't be so concerned about the labels that we put on agreements. But we should recognize that we've never had all members have all the same responsibilities, and perhaps use that as a way of reorienting how we think about these issues. So that's all I have. I'm going to stop sharing so I can see you, and I look forward to our discussion.
Professor Lewis, for your excellent, and I would say a very thought-provoking conclusion. So let me take the moderator's privilege and ask you a question. If WTO, the WTO agenda has to proceed, do you think that the sort of clinically dead Doha round agenda now needs to be somehow recalibrated, or it needs to be abandoned and the negotiation needs to start from some other footing, on some other basis, or still you see some future in the Doha round? Thank you.
Yeah, so I think that everyone believes and understands that the Doha round is over. However, there is a hesitance to say that officially because it's emotional and frustrating for the countries that expected to benefit from a round focused on development to say, well, we're actually not going to do that. So I think it is important to both move on, but also to recognize that a promise was made, and there needs to be a way to communicate to developing country members that we're not abandoning the commitment to developing country members, but we need to recast this agenda because that negotiation has stalled. And perhaps the way to do that is not to say we're abandoning the development round, but instead to say, look, it's now over 20 years since that negotiation started, and a lot has changed in the world. There are new industries, there are new products, there are new concerns, right? Climate change is now much more urgent. It was always urgent, but it's much more urgent now than it was 20 years ago. And that we need to perhaps come up with a more modern agenda to meet the times. But I think there is a real challenge in figuring out how to structure an agenda that meets the expectations and needs of developing countries while still getting the developed countries to come to the table because of this problem I described of the delicious food already having been exchanged. And as we know, the developed countries are not anxious to open up their markets to textiles and other products from less developed countries. So how do we get that to happen?
Thank you. Now, the next question that I would like to ask is, in many ways, I think literature is there that suggests that the WTO itself could be established because there was some significant push from some MNCs. So do you see any such parallel or lack of it in the Doha round or in coming days to, or maybe either to kickstart new negotiations or maybe to take it further through the WTO rather than bilateral or plurilateral?
Yeah, that's a good question. You know, some people have suggested that what we need is a total reboot, sort of a WTO 2.0, that the reason the WTO was able to be created was it was a moment that we wanted to have a more durable institution. The GATT was kind of this intended to be a temporary measure until a proper treaty could be concluded with an organizational structure. And to be able to do that was desirable on a lot of levels. And to get the WTO started by conditioning membership to agreeing to the whole package kind of presented a pretty unique opportunity to get everyone to agree to everything, even if the commitments were not identical across the members. So how can we replicate that in our current world without creating a brand new institution? That's a challenge. And it's one reason that I think perhaps we need to consider whether, is it really so different? Is it really lesser to have something like the Information Technology Agreement than to have TRIPS? Because the reality is not everyone is agreeing to the obligations, to be bound by obligations that apply to, the obligations don't apply evenly. But I think in terms of opportunities, I think perhaps we need to be creative to think about, even though the traditional items on the buffet menu have reduced, some of the items have been gobbled up and are gone, there are new items that we can consider putting on that table. And so even though the developed countries have certain things that they originally wanted, tariff, market access from each other, there are other things that perhaps they want today that developing countries could provide. And maybe by offering some of those things, the developed countries would be willing to provide to developing countries what they want. So just as examples, perhaps within these new chapters that are coming up in these WTO plus FTAs, it would be convenient for developed countries if the rules were the same across the world and not just between subsets of countries. So maybe there are some of those new issues that developing countries might say, okay, well, we could live with this one if we get X in exchange, and maybe stop having the discussion be about exclusively about market access in the trading goods context, but perhaps there are paths where more concessions could be made on, let's say, services in exchange to market access for goods or something like that. And then it's possible, I don't know how optimistic I am about this, if I'm honest, but it's possible that sort of looking at the model of the fisheries negotiations, fisheries subsidies, that we will get to the point, hopefully soon, that climate change is such an urgent problem that there will be an impetus to work together to say, look, we need to address this or other issues, and let's figure out a way that we can all work together, right? And so perhaps that will impel the developed countries to do the tech transfer to allow the developing countries to make commitments as well, right? So there are problems that, a problem such as climate change is universal. It's not something where the developed countries can just say, oh, well, not our problem, we don't want to help, you can bear the brunt. It is true that a lot of the effects of climate change are disproportionately felt by the global south, but it's going to affect everyone. And so that might be an impetus for kind of trying to find a way to cooperate with each other. But I can't, say this is all sunshine and flowers, because this is obviously a kind of a somber time in terms of multilateralism.
Thank you for that answer. My esteemed colleague, Professor Hilal Ahmad from our SB faculty, he has made some observations, not so much questions, but some observations. So let me raise them. He is arguing that WTO is still very much relevant. Spatial and preferential treatment has always been there. And these FTAs are stepping stones for multilateral trade liberalization. And maybe, I guess, broadly you agree, and most mainstream scholars in this area would agree with him. Now, in relation to that, one question that you have not addressed so far, but in a way you alluded to this, I think, is about the defragmentation of dispute settlement. We know about Mexico soft drinks and other cases. So to what extent do you think this has already been a feature, or in my understanding, perhaps not so much yet a feature? Is it because many of the trade lawyers and the panelists or judges, they have been more sort of public international law, taking more public international law approach, or is it just a coincidence which you think can change in future? Any thoughts on that, Professor Lewis?
Just to make sure I understand the question, are you asking why there hasn't been more dispute settlement within FTAs?
Not really. What I was trying to get at is that we have seen the Mexico soft drinks cases and sort of the challenge of WTO panel or appellate body saying something, and that issue also being litigated in another forum, or in NAFTA or other forum. So what about defragmentation of dispute settlement? Has that really happened, or may it happen? And also, Professor Ahmad has also made another point that when going gets tough with the WTO, the tough gets going with FTAs. Or maybe the sort of argument that some people have about sanctions, that even if there are sanctions, there would always be some sort of ways of getting across those sanctions, at least to some limited extent. So maybe your observations on that, and also this defragmentation of the dispute settlement issue. Any thoughts on that, Professor Lewis?
Sure. So I think that for the first wave of FTAs, what I call the traditional FTAs, we didn't see fragmentation, even though those FTAs provided for dispute settlement. And I think the reason for that was that there wasn't really a reason to use the FTA dispute settlement, in that the commitments in the FTAs were largely identical to the commitments in the WTO, except for the tariff reduction commitments. So there's most favored nation and there's national treatment, but there weren't chapters on things like e-commerce that were outside the WTO in substance. So certainly you could bring an MFN complaint to your FTA dispute settlement, but you could also bring that MFN complaint to the WTO. You would just frame it as a violation of the WTO MFN obligation, not a violation of the FTA MFN obligation. And because WTO dispute settlement has worked prior to the collapse of the appellate body, was working quite well, and was seen as the jewel in the crown and all of this, members were pretty happy with WTO dispute settlement. The panelists are supported by the architecture of the WTO institutions. You have a lot of staff support. You have expertise of panelists having already been part of several dispute resolution processes. And so with the WTO, you have an established jurisprudence. You kind of have a sense for how the system works, what you're going to get, and all this institutional support from the WTO. Whereas in an FTA, you have none of that. So why would you go to the FTA when you could bring the same issue to the WTO? Now, where I see the fragmentation problem arising is now we have these new style FTAs with chapters on state-owned enterprises and investment and e-commerce and other things. And now, what if you have a dispute and there's an MFN issue and an e-commerce violation? Well, you can't bring that whole dispute to the WTO because the e-commerce issue can't be framed as a WTO issue. There are no commitments on e-commerce in the WTO. So are you going to split that dispute and bring the MFN issue to the WTO and the e-commerce issue to the FTA dispute settlement? That doesn't make a lot of sense. Why are you going to have two parallel proceedings? So I do think that FTA dispute settlement will probably start to be invoked, and probably would have started to be invoked even if the appellate body were still functioning, just because issues will ultimately start arising in the context of commitments that don't have a parallel in the WTO. But in the absence of the appellate body problem, I think that that occurrence would still be not that common, not that frequent, because there is something very appealing about WTO dispute settlement, having all of that expertise within the institution, having all of that experience and support within the institution. So I think that that remains strong. But the lack of an appellate body now does complicate things.
Thank you. Thank you for that answer. Now, this was not really a core part of your presentation, but one participant has asked on this about the potential or already in the process of being implemented, the prospect that Russia would lose its MFN status. What about its potential legality? I guess as WTO students, law students, we know that which provisions are invoked, but do you have any views on its legality or illegality?
So I will just have a caveat that although I am, of course, following the news and following this, I have not thought this through deeply enough that I can give a completely confident response. But I will say that I think it is a slippery slope to invoke GATT Article 21, which is the national security exception, as a rationale for withdrawing MFN treatment from another member on the basis of its actions, not towards you, but towards other members. So I'm personally a bit conflicted about this one because I personally would like Russia to be put under as much pressure as possible to stop this clear violation of international law. But I don't think that Article 21 was drafted with this type of measure in mind. So I don't think the WTO agreement provides, at least in any clear way, that you can just withdraw MFN because you don't like what a member is doing or that it's violating international law with respect to another member. So I am dubious about the WTO consistency of this, at least in terms of what the drafters had in mind. At the same time, I'm not unsympathetic to the EU and the US taking this step, but I am concerned that it is a slippery slope. And so I think on balance, it's probably not the right way to go about this.
Thank you. I think that's a very careful and I would say legally very plausible answer. Now, the next question that I have received is on the special and differential treatment provisions reform. So as far as I understand, the question is not detailed enough, but as far as I understand, it's on particularly the US proposal and also EU proposal on making some sort of distinctions on who would be eligible for special and differential treatment and who would not be. So I guess that's a very contested area. So do you have any views from you on that, Professor Lewis, that to what extent this is a part of that single undertaking that it cannot now change in a way, or time is now that there has to be some significant reform? Do you have any views on that?
Yeah, so I think that I don't know the details of these proposals, but I have a general sense. I don't think that the idea is that, I don't think anyone has the idea that special and differential treatment should stop. But I think that the concern is that because the status of developing country is self-identifying, that there is a concern that this is being abused is maybe too strong of a word, but that it was not really intended that, let's say, a country that's in the G20 should be able to call itself a developing country. The idea behind building in special and differential treatment into the GATT and carry over into the WTO is to recognize that there are countries that are at vastly different stages of development and therefore have different needs. But a country that's in the top 20 wealthiest countries in the world surely does not have the same needs as a country that's in the bottom 20 in the world, or the bottom 80 in the world, or the bottom 100 in the world. So I think that this dialogue is probably arising out of a frustration that some countries that really do not have significant development needs are taking advantage of the WTO's structure, that you get to identify yourself as developing if you want to, even if everyone else would disagree that you're developing. I think that's where the tension lies. So I would imagine that in a negotiation over this, it's not going to be a question mark as to whether, the bottom 100 or 120 or wherever we draw the line countries deserve to continue to get special and differential treatment. The question is kind of from the top, where should the line be cut off? Not from the bottom, where should the line be cut off? Sort of, I think the concern is that we have countries that, I think still in some areas, Singapore considers itself developing, which is, I think, a real stretch, and South Korea. Now, they don't invoke it in every context, but, I think there will be easy cases in discussing who should stop calling themselves developing, and there will be harder cases. But fundamentally, even to have that discussion calls into question the principle that it's a self-identifying category. So that in and of itself provides a challenge, because some countries might actually acknowledge that they're not really developing, but at the same time not want to acknowledge that anyone else should get to have a say in this, because the rule is you get to identify for yourself. So are we going to change that rule? Or are we just going to rely on the good citizenship of the membership to not take advantage of this opportunity?
Thank you. Thank you for that answer. We are almost out of time, so this would be our last question. And it's a bit of a broad question. This question asks you to address the current trend of some South-South FTAs and what sort of an impact that may have on the future of the WTO. So your concluding thoughts on that maybe, and we'll end there.
Sure. So I think it's a very positive development that South-South FTAs are developing, that the All Africa FTA has developed. As I said, it's really not an option to just sit out this process, unfortunately, because you just become less competitive against your the countries with which you compete. At the same time, FTAs are clearly not a one-size-fits-all. It makes complete sense that, not every country is flocking to join the CPTPP. It's a very ambitious agreement with commitments in areas that it makes sense that many developing countries would not want to make those commitments. That would not be in their interest. So to form agreements with countries that have similar sort of development concerns, I think makes a lot of sense. It at the same time provides an opportunity to create some comparative advantage, right? If you liberalize between yourselves, you are creating new avenues of market access for each other, where you will be drawn to each other. And at the same time, you can acknowledge areas that you don't want to go into and steer clear of those. So I think that makes a lot of sense.
Thank you very much for that answer, and of course for your time and the presentation. Thank you all. We would end for now.
Thank you so much. This was a real pleasure.
See you again.
Thank you.